Hi there, my name is Drew. I'm a lawyer in British Columbia who helps people understand the law. As someone who has worked for years with nonprofit organizations in BC, I'm excited to be helping people understand a new law that affects nonprofits across the province. This new law, called the Societies Act, is in effect as of November 28, 2016. One requirement under this law for every nonprofit society in BC is to file a transition application with the government within a 2-year period after the new law takes effect. In this video, I'm going to cover how to prepare for transitioning under the new Act, 5 steps to get ready to file. First, there's an optional preliminary step to order a transition package. To file a transition application, you'll need to submit an electronic version of the Society's Constitution and Consolidated Bylaws. I'll explain what that means shortly. To put this material together, you may want to order a transition package from the corporate registry for $40. You don't have to do this, but it will make your life easier if you do. A transition package for a society includes certified copies of any documents that the registry has on file for the society, including the original constitution, the original bylaws, and any special resolutions amending the society's constitution or bylaws. You can use these filings to create complete consolidated versions of the constitution and bylaws, which are key aspects of getting ready to file. You can order a transition package online by going to www.gov.bc.ca/societiesonline. Now for step 1. Consider whether to become a member-funded society. On transition, you'll be asked whether your society wishes to designate itself as a member-funded society. This new designation is for societies funded primarily by members to carry on activities for the benefit of members. For example, private clubs or sports leagues. To become a member-funded society, a society must meet a qualification test and get the approval of its members in a special resolution. If a society doesn't adopt the member-funded society designation on transition, it will need a court order to do so later. The video, What the New Societies Act Means for Existing Societies, looks at some of the issues to consider and whether to become a member-funded society. Step 2. Ensure the society is up to date in its corporate registry filings. If any annual reports are outstanding, the society will not be able to transition. Also ensure that the information on file with the corporate registry about the society's directors and registered office is up to date. The most current directors and registered office information will automatically be included in the society's transition application. If this information is inaccurate at the time of transition, it will need to be changed by making a separate filing after the society's transition is completed. Step 3. Prepare an electronic version of the society's constitution. To file a transition application, you'll need to submit an electronic version of the constitution of the society with these modifications. First, the constitution must consist of only the society's name and purposes, which cannot be changed on transition. The name and purposes must be word for word as they appear in the society's constitution on file with the corporate registry. Second, if the Constitution currently includes any other provisions, these must be moved to the society's bylaws. For example, a society may have a provision in its Constitution about remuneration of board members, or about the disposition of its assets on dissolution. Such provisions must be moved to the society's bylaws as part of preparing for transition. We'll look at this more in the next step. Next, if your society has decided to become a member-funded society, as described in the first step, you'll need to add a statement to that effect to the Constitution. The wording is set out in the Act. Step 4. Prepare an electronic version of the Society's Consolidated Bylaws. To file a transition application, you will need to submit a single consolidated set of the Society's bylaws in electronic form. In other words, you must create one document that reflects the original bylaws as well as all subsequent amendments to the bylaws filed with the corporate registry. The single document can be a word processing document or a PDF. To assemble this document, the transition package described in the optional preliminary step can be very helpful. Once you have consolidated the existing bylaws, there are a couple of additional steps. For any provisions in the Society's Constitution, other than the Society's name and purposes, move those provisions to the consolidated bylaws. You can add them to a new part at the end of the bylaws under a separate heading, such as provisions from the Society's pre-transition constitution. Mark all unalterable provisions from the Society's pre-transition constitution as having been previously unalterable. This next part is really important. Move those provisions without making any changes. For example, a society might have an unalterable provision in its constitution about remuneration of board members. On moving this provision to the consolidated bylaws, it would look identical, but with the phrase, "This provision was previously unalterable" at the end. Next, if the society was a reporting society under the old Society Act, incorporate some new reporting society provisions into the consolidated bylaws. Reporting societies under the old Act include hospitals, insurance societies, and other societies that require government consent to incorporate, as well as any society that has a subsidiary. A society is not reporting just because it files annual reports with the corporate registry. The new reporting society provisions are in the Societies Regulation under the new Societies Act. They contain special rules such as the requirement to have an auditor. And finally, step 5, review and possibly alter the society's bylaws. A society that rearranges its constitution and prepares consolidated bylaws, as described so far, without any other amendments, can proceed directly to file the transition application. The society does not require member approval and can proceed with the transition without holding a general meeting of members. It is a best practice to seek board of directors approval at this stage. There is one more step, though, that is highly recommended before filing a transition application. This is an ideal time to conduct a review of your society's existing bylaws. Any provision in your society's bylaws that is inconsistent with the new Societies Act has no effect. The matter is governed by the new Act. Having bylaws that are inconsistent with the new Act is a risk. Effectively, you can't trust your bylaws between November 28, 2016 and when you conduct a review to ensure that they are harmonized with the new Act. There are also important opportunities to take advantage of the increased flexibility offered by the new Act. The next video, Reviewing Your Society's Bylaws, takes you through the steps of conducting a bylaw review.